appearances on the record, please.
My name is Tim Eyman, appearing pro se as a pro se petitioner and litigant.
And for the defendants?
My name is Leslie Griffith, Deputy Solicitor General, appearing on behalf of the state defendants.
Excellent. The court has reviewed this file. I am prepared to hear the argument today from the parties, and I would appreciate it if we could limit each argument to 10 minutes per side. I will remind you as we get close to that limit. Mr. Eyman.
And is it okay if I don't take the full 10 to do it in rebuttal?
Absolutely.
That's okay. All right, very good. Well, thank you, Your Honor. Me being loud is not going to be difficult. So this is my natural voice, so I think I should be okay on her hearing me. I guess I would start with, we've been here before. This challenge was before you, Your Honor, just 2 years ago on partial vetoes by the governor on a couple of bills. The principles are the same, the bills are different, so in a lot of ways, I'll just leave copies of briefs that were written 2 years ago that resulted in a favorable ruling saying the partial vetoes had exceeded the governor's power, and rather than reinvent the wheel, I simply copy and paste it, which is legal in the legal profession, but probably not anywhere else. So a lot of this is going to sound familiar to you. You're obviously very familiar with the issues related to it. The point I would start with is the voters twice said no to higher carbon taxes. So the legislature implementing two policies that went against what the voters wanted was something that they would be hesitant to do. So they passed two bills that would pass the policies but delay them until a later date. The governor ended up seeing that and essentially rewrote the legislation and vetoed the delays in the bill. And what I'm struck by reading the previous briefs was that in 1974, the legislature referred a constitutional amendment to the November ballot, and it proposed to permanently and severely restrict the governor's veto power. And in the voter's guide, it specifically said, help rid your state of one-man lawmaking. Washington is the only state in the nation in which the governor exercises unlimited power to remove portions of laws passed by the legislature. This joint resolution will prevent one person from changing behind closed doors of his office bills which are the product of an open hearing process, accessible and visible to all citizens. And the voters overwhelmingly passed that. And that's what the legislature did here. They passed two bills that enacted a low-carbon fuel standard and the other bill that imposed a cap and tax scheme. In both bills, they explicitly delayed the implementation of those policies. And it was referred to in the legislative session as the grand bargain. And the governor essentially broke the grand bargain in his partial vetoes, and he admitted to doing so by amending the bills and overriding the legislature's decision to delay the implementation of the bill's policy. So what this writ is requesting of the court is to simply require the Department of Ecology and the governor to follow the law as it was written, which is to delay the implementation of these policies. As the Attorney General stated in his legal brief before this court on January 17, 2020, the governor may sign or veto a bill, but the Constitution denies him the power to edit a bill or change its structure. And this court agreed with that argument and ruled against the governor. And as you know, the state Supreme Court recently affirmed your decision. In the veto message on the low-carbon fuel standard, he said, we cannot delay its implementation, quote unquote. For the cap and tax, he said the delayed effective date established in subsection 7 unnecessarily hinders our state's ability to combat climate change. And reflecting the separation of powers implicit in the state constitution, Washington courts recognize that structuring a legislative bill is the exclusive province of the legislature, not for the courts or the governor. So I would simply say, regardless of how I'm before you, I am a pro se litigant, it's your call. Did he exceed his authority or didn't he? Did he do exactly what he did before, and that's to do portions of bills? And in this case, we're dealing with a single subsection. He vetoed 3 words in section 8 on page 20, a single sentence, 3 words on page 39, and 3 words on page 47 of one of the bills. And that is just rewriting legislation. And what the writ asks you to do is to either prohibit them from implementing the laws now, which is what they're doing because of the partial vetoes, or require them to follow the law. Either way, it's 2 sides of the same coin, simply trying to get them to abide by what I would argue was the court's decision already, but also what the legislature expressly did. And with the entire concept of 3 co-equal branches of government, you can't have one person making all decisions. There has to be checks and balances. And in this case, I'm asking you, Your Honor, to be that check on the governor again like you were before. So I will address some of the issues raised by the Attorney General's office, again trying to keep it brief, but I'm struck by how much emphasis they made over the issue of Mr. Eyman isn't personally harmed enough in order to challenge this decision by the governor. And I'm struck by that because many of our initiatives have been challenged by somebody who rides on a bus is considered enough harm to them for the passage of our initiative for them to have standing. In this case, I am a licensed driver, I am a taxpayer, I am an initiative activist that needs an initiative process that people can trust. And when you have the voters saying no to these policies, and then the legislature adopting them, but at least acknowledging the voters' hesitancy and delaying them, and then watching the governor say, well, no, I don't want them delayed, I want them now, that really undermines the faith in the system. So I was struck by the fact that the Attorney General representing the governor spent all their time saying, don't decide, Judge, don't decide. And I'm asking you to decide. Either he did something that exceeded his power or he didn't. There are no facts in dispute. We all agree the bills passed. We all know what was in the bills. We saw what he struck down. And it's just a clear case where they exceeded that authority. If there's any time left, I'll do it with a rebuttal. But I would just simply emphasize that it's frustrating for voters to be ignored. I don't think it's a stretch to say that the legislature doesn't like being ignored either. And I don't think the courts or judges like being ignored. And in this case, it seems that the governor went way beyond his authority and doing something that he was found guilty of already, but just simply doing it again. I have 3 kids. I get frustrated when they don't listen to me. So I think in this case, I think you need to take a parenting role and say, Governor, you just went too far this time, just like you did last time. So if I have any time left, I'd appreciate the chance to rebut. Thank you.
You have 3 minutes remaining.
Thank you, Your Honor.
Ms. Griffith.
Thank you, Your Honor. Morning, I'm representing Governor Inslee, Director Watson, and Washington State. And I'll just make a couple of points this morning and then respond to some of Mr. Eyman's discussion. I really want to focus us on what the motion pending here today is, a motion for a writ of mandamus or a writ of forbearance. And both of those are extraordinary remedies. And they are drastic remedies. And because of that, there are several independent requirements that must be satisfied before those remedies are even available. And even if those remedies are available, there still must be an equitable consideration about whether it serves equity to issue those writs and whether it serves the public, not just a private interest. So first, I would note that none of these independent requirements have been satisfied here. And I'll just walk through them very quickly because we talked about them in our response brief. But none of the allegations in the motion or in the amended complaint have been attested to by affidavit or verified complaint as is required for a writ of mandamus or prohibition. Second, Mr. Eyman has not demonstrated that there is no plain, speedy, and adequate remedy available at law. Indeed, Mr. Eyman has filed an action for declaratory and injunctive relief, this very same case, and that case is just getting off the ground. So the answer to the amended complaint was filed just days before the motion for writ of mandamus or prohibition. So in that case, we have a remedy at law available, a process at law available that Mr. Eyman is making use of and looking at these issues in the context of a motion for mandamus or prohibition would circumvent that ordinary course of litigation. Mr. Eyman also, and we discussed this, has not demonstrated that he's beneficially interested here, and the law is pretty clear that this does not require a generalized interest, it requires a particularized interest beyond sort of a general population interest. That the only interest discussed actually in his motion for writ of mandamus was a concern for the court's docket and hypothetical future veto litigation. We haven't discussed that here. The concerns raised in his complaint and today about being a driver or taxpayer, those are not the sort of particularized concerns that can count as a beneficial interest that would justify invoking a writ of mandamus prohibition. But there are more fundamental concerns here, and that's really that the dispute at issue here in this action for declaratory and injunctive relief are not the sort of ones for which a writ of mandamus or prohibition is appropriate, because there is no clear duty identified that should be required in the case of mandamus or prohibited in the case of a writ of prohibition. So with respect to a writ of mandamus, the action that must be identified to be compelled must be specific and it must be ministerial. So that goes beyond just sort of a general thing that is required, but it must really be a truly non-discretionary duty. And anything involving the veto power is discretionary. The word in the Constitution is may. So it's a discretionary power, but here there isn't really anything that Mr. Eyman has identified other than today a command to follow the law generally. And Walker versus Monroe, the court said mandamus will not lie to compel sort of general requests to follow the Constitution. That's just not what mandamus does. So again, there is not a specific ministerial duty here, one that doesn't involve any policy judgment or discretion that Mr. Eyman has asked the court to issue a writ of mandamus for. Turning to prohibition, the analysis is sort of a mirror image. Is there an action that Mr. Eyman has identified that is clearly outside of jurisdiction of the defendants? And here the answer is no. So this is not a situation of normal judicial review or error correction. It's one where there is a total and inarguable lack of jurisdiction here, and that's not what we have. And finally, the point I'll make before responding to a couple of Mr. Eyman's concerns is we really don't want to short-circuit the normal course of litigation here, and I think it would disserve the public to do so. And I think that it goes to the question of whether there's a plain, speedy, and adequate remedy at law, as that there clearly is, because there is this existing action for declaratory and injunctive relief. But it also goes to the equities here. We have a litigation that is in its very early stages. There's certainly been no delay, but what we have here is a question that is important, and that the legislature has also sought to be heard on in their own action with regard to the clean legal standard. And so addressing this here on a motion for an extraordinary writ would short-circuit that process and disserve resolution here. Just a couple of points. Mr. Eyman brought up legislature v. Inslee and your decision on the Supreme Court's decision there, and we don't need to address the merits there. We disagree with this characterization here, but I think the point is that in the context of a motion for an extraordinary writ of either mandamus or prohibition, we don't need to get into those issues because he has not satisfied the elements required to invoke those writs, and because there is not a specific ministerial duty identified. We also disagree with the characterization of the Clean Fuel Standard and the Climate Commitment Act and their relation to the initiatives that Mr. Eyman has identified. But again, even his work as an initiative activist cannot establish a beneficial interest here. We need the laws to need something more particularized. And finally, Mr. Adams again requested today that the writ issue to compel Director Watson and Governor Inslee to follow the law as written. And that is simply not what these extraordinary writs are designed to do. They are drastic measures and they are very targeted measures. That a generalized request like that is simply not an option, whether the writ of prohibition or the writ of mandamus.
Thank you. Mr. Eyman.
I believe what is extraordinary that's needed is for the governor and the Department of Ecology to follow the law as the legislature passed it. Writs are very common. They're a proper remedy to compel an elected official to do something they're required to do. And in this case, the Supreme Court affirmed your decision that they had exceeded that authority previously, and here he's doing it again. I notice they don't defend vetoing individual words, individual sentences in bills. He said they don't have to. I think they do. I think they owe it to the public to explain why it is that that's okay. I'm also struck by the fact that the legislature has only challenged one of the two bills and only did it after I filed my own lawsuit. So if I'm not allowed to be able to challenge this stuff, they're essentially saying no one can. And I don't believe that we should have unchecked power in any one branch. You have to have checks and balances in that system. And I did follow the rules that were laid out before me. Writs are very common. And as I said in my response to their reply, I am somehow worried about hypothetical future vetoes. Yeah, but this motion is about just these. These partial vetoes individually cut out portions of the bill which exceeds the governor's authority, and clearly they don't want you to decide this. They want you to kick it and allow them to start implementing policies that the legislature said they didn't want to take effect immediately, that the voters have twice said no to. Allow us to just keep doing what we're planning on doing and don't get in our way. I don't think that that's a good system. It's not a system that the voters really appreciate, and I think we do have to have these checks and balances. I brought this lawsuit forward because I did see 3 days earlier the Supreme Court uphold your ruling, and I thought, as cynical as I am about the court system, I thought, well, at least if he's doing the same thing, they'll rule the same way. It is different this time because it's me bringing a challenge versus the legislature. But if it wasn't me, who else would? And it seems to me that I'm at least as harmed as anybody else, and I think I am particularly harmed by it because I am an initiative activist, and I think I've certainly reached the level of harm that's at least equivalent to the harm to anybody that's ever challenged any of our citizen initiatives, and I don't think there should be a double standard where it's easy to sue against an initiative versus it's hard to sue against an executive overreach. I would just ask the court to not condone or excuse the governor's partial vetoes in 2021 by ruling differently than it did with his partial vetoes in 2019. The violations are the same, the principles are the same, the names of the bills are different, but it's the same idea, and I believe that the voters the governor's attorneys, the Attorney General's office said the public would be ill-served by you deciding this. I believe the public is ill-served with the status quo, which is they're starting to implement policies that the legislature specifically said they didn't want to take effect yet. That, I believe, is the untenable situation, and I urge the court to rule in favor of the writ and work with us to do it in a way so that it is appropriate and proper. Thank you.
Thank you.
Unless you have further questions.
I do not. The court is prepared to issue a ruling at this time on the motion for writ of mandamus or prohibition. The court has considered the motion and briefing on the motion as well as the entire file. This is a case brought as initially a complaint for declaratory judgment. That is the nature of this case. The motion for writ of mandamus and prohibition is denied. This court believes strongly that this case presents important issues that need to be resolved on their merits. The court must follow and may not exceed its own authority. And the court, in looking at this motion, is not denying the motion based upon the arguments of lack of beneficial interest or lack of affidavits. The plaintiff has brought forth a legal issue that the court is not contravening today. I'm basing my ruling today on the assumption that the plaintiff is correct as to the legal ruling that the court previously provided and the Supreme Court, more importantly, has provided in addressing the legal issue. But that doesn't resolve the entire motion today. This court must determine, based upon the appropriate legal standard, whether, even if plaintiff is correct with regard to the assertion that the governor exceeded the governor's authority in the particular act at issue in this case, whether the remedy is appropriate. And that's where the court begins its analysis. And the remedies being requested, writ of mandamus or prohibition, are extraordinary remedies. That is a term of art in this area of law, and it doesn't mean that they're never issued. It means extraordinary in the sense that certain steps must be taken first before the court can issue this extraordinary remedy. Once again, the court may not exceed its own authority in issuing remedies. Therefore, the court must consider whether this remedy is available at this time, at the early stage of this case that involves declaratory judgment. This is not a motion for declaratory judgment. It is a motion for mandamus or prohibition. And the legal standard that applies to grant that remedy is very clear and a very high legal standard. One requirement is that there is no clear, plain, and speedy relief available, and therefore mandamus or prohibition is really the only reasonable relief. That standard cannot be met here. In addition, the record here does not identify any specific action to be compelled that meets the standard for prohibition or mandamus. Therefore, the court must deny the request for mandamus or prohibition under the circumstances in this case. And once again, the court, in ruling on this motion, is not making a determination of whether the governor exceeded his authority, but I'm assuming that that is correct for the purpose of this hearing today. But even if that is correct, the standard for the remedy requested cannot be met. The court wants to make very clear that in denying the motion before the court today, the court is not dismissing this case. This case, at this point, will go forward in the normal course, and I anticipate further motion practice. It would be appropriate on any civil case, including this one for declaratory judgment, for the parties to brief the merits on a briefing schedule that would include multiple briefs over time for the court to address the merits of the case or any other procedural issues, which I'm not precluding at this time. I'm only ruling on the motion before the court for today. Based upon the court's review of the authority cited in all of the briefs, the parties' oral arguments, the court is denying the motion. Do the parties require further clarification of the court's oral ruling today?
I do, but see if they have something.
Ms. Griffith?
No, Your Honor.
Mr. Eyman?
I think I heard you correctly, but I want to understand it, is that you're retaining the case. You're still the judge of record on this complaint, on the motion, and that further motion, for example, let's say on Monday, I would file a motion for declaratory judgment and injunctive relief. If I were to file that, I'm not being assigned to a different judge, starting all over again. I'm simply filing it in this court before you. Am I getting that correct, that you're retaining this case and it's not, I don't have to start over? If I understand correctly.
The case is not dismissed,
Okay,
and the case is assigned to me.
very good. I just want to make sure I understood that correctly. Thank you
So
for that clarification.
I wanted to be very careful in answering your question because I don't control other things that happen, but I don't anticipate any reassignment of this case to any other judge. That happens sometimes in the case of a notice of disqualification or recusal. That has not happened in this case, and today's hearing is an exercise of discretion that would preclude a future notice of disqualification in this case.
That makes sense.
So, as far as I know, the case will continue to be assigned to me as long as I'm in this rotation, which I plan to be in. And the court today is only ruling on a motion, not deciding the future of this case. Does that help?
It helps tremendously. Thank you for that.
I do have an order that's been presented, but I don't know if the parties want to confer regarding the form of an appropriate order that reflects the court's ruling today. Mr. Eyman, would you like to take that opportunity?
I believe so, but I would assume the Attorney General's order just says is denied. Is that?
It does. Did you want to review that? It's in the court file and probably mailed to you, but do you want to review that and have me sign it today, or do you want to take some time?
No, you can go ahead and sign that one if that's all it says, is that particular motion was denied. That would be fine.
So I'll read it into the record just to be
Please.
clear. The proposed order that was filed on January 18th states as follows. This matter having come on regularly for hearing before the undersigned judge of the above entitled court, upon motion of plaintiff for a writ of mandamus or prohibition, and the parties being represented by their counsel of record, and the court having examined the records and files therein, having heard the arguments presented, and being fully advised, now therefore it is hereby ordered that the plaintiff's motion for writ of mandamus or prohibition is denied. Obviously, the court will need to make a note that Mr. Eyman represented himself at today's hearing. Other than that change, are there any objections to the court signing that order?
There are not.
No.
And I have signed that order. I will hand that to the clerk, and it will be in the file where the parties may obtain a copy of it by going through the clerk's office or utilizing the court's case management system. Are there any questions at all before we complete this hearing? We are completed. Thank you.
Thank you.
Thank you, Your Honor.
And so I